this particular change, Indian avatar of the Lady Justice, the controversy which has come up is absolutely of no consequence as such. Justice can never be said to be blind. Article 14, Article 21, and even Article 19, they can never be separated. Justice Chandrachud has made justice open. Live telecasting, proceedings of the courts, it is reflective of the vision of Justice Chandrachud, of justice as such. In 2019, Article 370 was removed. The Chief Minister, for the first time, has taken oath in the name of the Indian Constitution. Reservations, caste system needs to go away. 75 years is a long time.
As we celebrate the 75th anniversary of our Constitution, we are honoured to have with us Dr. Balram Gupta, Professor Emeritus of Law and former head of the National Judicial Academy at Bhopal. Dr. Gupta is a very eminent and highly acclaimed academician who has taught Constitution not just to the students of law but to judges as well. And so he is uniquely placed to give us invaluable insights on Constitution.
Thank
so
you.
Welcome, Dr. Gupta. It's so kind to be with us today. And
thank you so much.
So I will start with the change in the new avatar of Lady Justice. So that has been changed. And this is to mark the completion of the 75th anniversary of the Constitution. And there was a lot of talk about this. So what would you like to say about this?
See, let me put it this way. This particular statue of Lady Justice has been in existence for a long time.
Okay.
The lady blindfolded, a sword in one hand and the scale in the other. We are used to that for so long, all across the globe for that matter. The new Lady Justice, in that particular context, the change which has been made is no blindfold, no sword in the hand, the Constitution in one hand, the scale in the other hand. And she is wearing a sari for that matter. This statue has been installed at the reception of the Judges' Library in October 2024 by Chief Justice Chandrachud in that particular context. The controversy which has come up is absolutely of no consequence as such. The fact of the matter is, this Supreme Court building was inaugurated in the year 1958. And in the Judges' Gallery, there is a mural. Mahatma Gandhi on one hand, the Lady Justice on the other hand, and between that, those two, there is a wheel of justice. Now, this Lady Justice in that mural has no blindfold, no sword, the Constitution.
Okay.
So this particular change, Indian avatar of the Lady Justice, belongs to the year 1958 when this building was inaugurated in the Judges' Gallery. What Justice Chandrachud has done on the completion of 75 years of the Indian Constitution, at the entrance of the Judges' Library, this statue has been placed over there, signifying that Constitution is supreme. The sword has no relevance in the constitutional system for that matter. Justice can never be said to be blind.
Yes.
Initially, it used to be said that the judge should not know the parties and do justice in that context, therefore the blindfold for that matter. This is actually not so. When a petition is filed in the court, every detail of the individual party is given in that. The other side details are given. How do we say that the judge doesn't know who are the parties before the judge? It's a myth, absolutely. And therefore, in a constitutional system to say this, the judge should be blindfold, is absolutely not acceptable for that matter. And therefore, since Justice Chandrachud has made justice open, live telecasting,
Yeah.
the
Yeah.
proceedings of the courts, virtual arguments by the lawyers, everything is open for that matter. And therefore, to say this justice is blind is not acceptable. This, in fact, is the richest contribution, though, of course, the mural was already there, but it is reflective of the vision of Justice Chandrachud, of justice as such, that he has made it open and accessible to everyone for that matter to see for this. And therefore, this is something which is laudable and must be accepted.
Absolutely. And sir, I wanted to ask you, just the J.K. Chief Minister, it's for the first time after independence that he's taken oath on the Indian Constitution. So,
Dr. B.R. Ambedkar was the chief architect of the Indian Constitution. Pandit Nehru was wanting to give special status to the state of Jammu and Kashmir. Sheikh Abdullah was after that. And Nehruji asked Sheikh Abdullah to go and meet Ambedkar. He came and met him. Ambedkar told him that you want everything for Kashmiris in Kashmir. Don't you think the Indians also have to come into that? It was not acceptable to him. Ambedkar told Sheikh Abdullah that if you were the law minister, what would you do? In any case, Pandit Nehru prevailed. Article 370, special status was given to the state. And we know that history for that matter. In 2019, Article 370 was removed by the Government of India by a particular procedure that they followed. And in December 2023, a constitution bench upheld that particular. Justice Chandrachud was party to that as such. And therefore this special status no more exists. And in that context, the Chief Minister for the first time has taken oath in the name of the Indian Constitution.
okay.
And let me add a word to that. See, I have grown myself. Any legislation of the Indian Parliament, it would be applicable to all the states except the state of Jammu and Kashmir. That situation would no more be there. J&K, Ladakh, they are integral part of India
Absolutely.
as such.
And so, what is the most significant constitutional development that has taken place in these last 75 years of the Constitution?
You know, I would put it, Keshwananda Bharati.
Okay.
It laid down that the basic structure of the Indian Constitution cannot be altered, damaged, tinkered as such. And there is a reason behind that. Why did they say this? That the Constitution was being amended so frequently that even the essentials and the basics of the Indian Constitution were being tampered with. Constitution is a heritage. Protecting the heritage is constitutional morality.
Absolutely.
And therefore, in that particular context, it's not only the basic structure, even constitutional morality, both these concepts, the expressions have been used in Keshwananda Bharati's case.
Okay.
And they have grown together during the last 51 years since Keshwananda Bharati's case.
And why is that till today the appointment of judges is always shrouded in some controversy or the other? And, it's said that judges appoint judges. And we have the collegium system, but often in newspapers, even in normal discussions, this issue keeps cropping up.
This particular myth that judges appoint judges needs to be understood. Is it that judges alone appoint judges? Every other constitutional authority and other authorities are appointed by the government themselves. And to accuse this, that judges appoint themselves, judges, is not something which fits into the basic system for that matter. If they can appoint every other authority, why should the judges be not appointed by judges? One. Secondly, it is wrong to say that judges are appointed by judges. Only thing is the procedure is initiated. The names are initiated by the judges, the collegium for that matter. And a full procedure is followed. It goes to the chief minister, it goes to the governor, it goes to the central government, the law ministry, the home ministry. And after that processing, it comes to the collegium in the Supreme Court. And thereafter, once the collegium clears, then the appointments are to be made. To say this, that this only the judges are involved, absolutely not correct. I would like to share with you my brother, Justice Gupta, Jawaharlal Gupta. He was the Chief Justice of Kerala High Court. Certain elevations were to be made. What he did was, he asked all the brother judges to suggest names who are worthy of being elevated. The names which were common, they were picked up, and the registry was asked that these are 10 names, 5 of them, their cases be fixed before the first division bench, and the other 5, their names, the registry should fix up their cases before the second division bench for the next 2 months as such. And on the completion of 2 months, they were watched. Their performance was watched in the 2 division benches. One was headed by my brother, but the other. After 2 months, the lawyers of the second division bench and the first division bench, and the lawyers of the first division bench to the second division bench. Another 2 months. So that each one of them has been duly watched their performance in that context. And finally, the names were. Those names which were finally carried out, they were invited for a dinner at the residence of the Chief Justice. See that how they conduct themselves. And after doing that exercise, the names were recommended by the collegium as such. After the names were sent and were with the Chief Minister, I'm sharing what actually happened. Chief Minister Anthony called up my brother. I want to meet you. He said, how much time do you want? He said, about 45 minutes or so. He says, come for dinner. They met. And in the process, Anthony, the chief minister, says, some deserving names have not been included in that. My brother shared the entire
The process,
exercise which
yeah.
was done and told him, I have done my homework. If you have any better name to suggest, give me that, I'll consider. Otherwise, my list is final. And it must be said to the credit of Anthony, thereafter he didn't say anything at all.
That's amazing. That's very nice. Yeah.
Now, see, if the appointments are made in that particular manner, see, the whole system works in a particular process for that matter. Nothing can be attributed in that context. Let me share another story. Chief Justice M. Venkatachalaya, he was a judge of the Karnataka High Court. His name was under consideration for elevation to the Supreme Court. Now, when it was under consideration, and in fact it was final as such, the law minister, the then law minister, asked Venkatachalaya that the Prime Minister has desired that you should go and meet him. His name is under consideration. He says, why should I go and meet the Prime Minister? He says, if you are elevated at this stage, you would be, in due course of time, the Chief Justice of India. He said, perfectly fine, I don't need to meet the Prime Minister for that matter. The law minister says, do I have your permission to tell the Prime Minister that you have refused to meet him? He says, yes, when I'm refusing, why should you not tell him? And let me tell you, to the credit of the Prime Minister, then Prime Minister Rajiv Gandhi, when the law minister told him, immediately he cleared his file and said, I feel so good that we have judges of this stature, that they can even refuse to meet the Prime Minister. And therefore, see, the collegium system may need some changes as such, but I don't think we can find a better system for the appointment of judges for that matter. National Judicial Appointments Commission was constituted by an act and constitutional amendment 2015 and the judgment of 2016 in that context. The amendment was struck down as violative of basic structure, the independence of the judiciary for that matter. Now let me just briefly touch that. 6 members of the commission, 3 the judicial, Chief Justice and 2 senior most judges from the Supreme Court, the law minister, 2 nominated persons not from the field of law and justice, other citizens of the country. Now, with this composition, one may not have any issue and problem. Further, normally any commission is the odd members and not the even members, because in case 3 and 3, then the chairman of the commission has to have a casting vote.
Yeah.
That's always. No casting vote. If 2 members take one view about any candidate and 4 others take the other view, the view of the 2 members would prevail over the 4 members. I mean, this can never be accepted for
Yeah,
that matter.
absolutely.
You would agree
Absolutely.
on that score.
Yeah.
Which means that the whole system was not acceptable. This is undermining the independence of the judiciary. The three
Absolutely.
Chief Justice of India and two other members. I mean, two members overruling between
Yeah,
the Chief
yeah,
Justice and
absolutely.
two judges,
Yeah,
senior most. It's not an acceptable thing.
Thank you.
And this happened in 2016. Till date, they have not come forward with a better composition
Okay.
of the commission for this. And therefore, it's unfortunate that at times certain issues arise, but the system needs to be strengthened in this very context.
Absolutely. So, Articles 14, 19, and 21 are considered the golden triangle of the Constitution. So, do you subscribe to this?
Absolutely. You know, to begin with, it was interpreted that Article 14, Article 19, 21, and other articles also, they are independent. They are separate codes of their own for that matter. But then they realized that no, they are twins for that matter. Article 14, Article 21, and even Article 19, they can never be separated.
Okay.
See, each situation, Article 14, equality, equals to be treated equally. Now, it has been interpreted any action which is arbitrary is equally discriminatory and therefore violative of Article 14 of the
Absolutely.
Constitution. Arbitrariness is the foundation which has to be struck down, totally for that matter. And therefore, any such classification which is to be made, reasonableness is the first element in that particular context. Now, take for instance Article 19. 7 different freedoms have been incorporated in that article.
Thank you.
I would just take one, demolition, which is the current,
Yeah,
and that's
yeah.
the biggest challenge that we met. If somebody's residence is being demolished, or the place of work you are depriving of to that person the right to live, the residence is not there, and the right to carry on your own work, profession, business for that matter. Now, even if you are a criminal, the Supreme Court says, you have to follow a procedure. And you can't say, just come, because you are a convict, that your house is to be demolished. This can't be done for that matter. The foundation of Article 19 again is reasonableness. Restrictions which are reasonable in nature can be imposed on those freedoms. Freedoms are not absolute. Reasonable restrictions can certainly be imposed. And therefore, the guidelines are now being provided by the Supreme Court in regard to this. Article 21, for that matter. You know, right to life, personal liberty, cannot be denied except by procedure established by law.
Absolutely.
Now, right in the beginning, A.K. Gopalan's case, it was said that any procedure which the law lays down would meet the requirements of Article 21 of the Constitution. Now, if that procedure is devoid of principles of natural justice, the procedure is arbitrary as such, it cannot be accepted. Or if there is no procedure for that matter. Maneka Gandhi's case, They interpreted procedure established by law means such procedure which is reasonable, just and fair.
Absolutely.
And therefore, right to life and liberty includes such a wide range of rights for that matter. And in that particular context, they can be denied only if the procedure is reasonable, just and fair. Take for instance, during the emergency, Article 21 was suspended. You know what all happened, and you
Absolutely.
don't need to go into that. But immediately thereafter, Article 21 now can never be suspended. The experience showed this, and therefore, Article 21 would always remain intact. The right to life, personal liberty can't be denied like that. Now, in this particular context, the only yardstick which is there, reasonable, just, and fair, is something which is the contribution which the Indian judiciary has made it.
Okay.
And therefore, if Article 21 is there, and if reasonableness is not there, what is the use of Article 21 for that matter? That's the situation. And therefore, all these three constitute the golden triangle of the Indian Constitution.
Thank you.
So much has happened. They are the real protectors of the citizens of the country.
So, what has been the biggest constitutional challenge in the last 75 years?
Reservations, SCs and STs. Dr. B.R. Ambedkar, once again, he was of the opinion that 10 years period which was initially put for the reservations
Thank you.
was too small. But he felt that 20 years or so could be something absolutely in order. We have continued with that system for 75 years. I have no clash, but one particular thing which is bothering my mind,
Thank you.
having experienced the Constitution for so long, that these 75 years, they have not been able to merge with the mainstream. They continue to be known by the caste which they belong to as such. The purpose of bringing them up is to merge them with the mainstream. The tag must not continue. It's the tag which is the main particular challenge that we are experiencing today for that matter. I'm saying this, many belonging to that caste, or castes for that matter, they have done extremely well.
That's the creamy layer, they call it. Yeah.
Say, not only the creamy layer for that matter, you know, they are selected of their own merit when they compete. I have experienced this. We used to make admissions for law there. And even otherwise, in the positions, they compete. And in the open, they score much better than many others, for that matter. They are selected. And therefore the reservation goes, the quota goes only to those who could not come up to that merit position for that matter. Now, those who are selected on their own merit, and yet they are being tagged with that particular, that they are the Dalits as such, it is reflective. We need to change that mindset.
But politicians seem to be encouraging it. Now we are going to have caste census.
See, that is what I'm saying, that this is now the biggest challenge. Caste census.
To rise above.
See, as long as it would continue, they would never merge with the mainstream. See, give them all what you need to bring them up. Even in the high caste people, There are people who are socially backward,
Hanji.
educationally backward, economically backward. They belong to high caste, but they are backward as such. You are also giving them whatever required. They also should be those who are socially, economically backward. Bring them, give them whatever needs to be given. But caste should not be the basis of that.
We have a long way to go, I guess.
I know it's a long way, but sooner we do it. In the last quarter of the Indian Constitution, centennial celebrations that we look forward to, if we can't achieve now, it would not be something. See, what is the difficulty? Caste system needs to go away. 75 years is a long time.
Yeah.
It's not something small for that matter. I was at the National Judicial Academy recently, last month. We had the High Court Judges program. And we discussed this. I said, this is the challenge. Interpret the Constitution in such a way that this tag must get removed.
Absolutely.
And they must become a part. See, I'm not that why should they not be given? Give them whatever you want to, but remove the tag.
Yeah.
That
Don't-
is the main problem that we are facing.
Hanji.
It needs to be absolutely taken care.
Absolutely. And so, what role are judges required to play? What role they should play to strengthen the Constitution?
The judges are to uphold the Constitution. The judges are not to play the role of the opposition. The judges are not meant to appreciate the politicians and others for that matter. They have to see what the constitutional discipline requires,
Hanji.
and they must come forward with that particular aspect of this matter. See, Justice Chandrachud for that matter, many of the controversial constitutional benches, the Chief Justices earlier were not coming forward. How do you judge a judge for that matter? He's come forward, taken up those particular constitutional matters, decided them. It's not that when you decide in favor of the government, the judiciary is not independent. Or you decide against the government, judiciary is independent for
yeah,
that matter. That's the main thirst for this. And therefore, in that particular context, the role of the judges, how to ensure that the Constitution is carried out, and not to play the different other roles which I have just touched upon.
Yeah. Yes.
This is where the Justice Chandrachud's contribution is tremendous. And I would like to share here that story of the political thinker, Harold Lasky. See, he wrote a letter to Justice Holmes of the US Supreme Court. And he says, how much I wish if the people could realize that judges are human beings. Justice Holmes wrote back saying, how much I wish if judges could realize that they are human beings. See, this is the realization which the constitutional courts have to make the people realize that. Judges are human beings. They have to be compassionate, empathy, and at the same time, no arrogance, only elegance. That is what suits the judges for that matter. And in that particular context, if the judges play their role, it would be something which has been done during the time of the Chief Justice, Justice Chandrachud. You know, I feel his contribution is tremendous comparing with others as such.
And what is it, the general thought we grew up being told that a judge has to remain away from the rest of the world and so that he's not influenced by anyone?
Good that you are asking me this. Times have changed. With this kind of open system that we have, that the judges are confined and not to be participating or looking in the public for that matter, or the kind of a situation which arose, the puja part of it as such. I recall Chief Justice Gajendra Gadkar. At that time, the Prime Minister was Lal Bahadur Shastri. They were living, when their residences were close to each other. Often, the Prime Minister would walk and come over to the Chief Justice's residence, or Chief Justice Gajendra Gadkar. In his autobiography, he has shared this. He would walk over to the Prime Minister's residence. Now, I give you one example. A certain judge was to be transferred because he could not carry the brother judges along as such. The kind of leadership which a Chief Justice should be providing, he could not do that. Now, he was to be transferred from one high court to another high court, and naturally the other high court Chief Justice had to be brought over there. One of the Chief Justice was agreeable to that, but the one who could not lead the team well, he was not agreeable. Gajendra Gadkar shared this problem with the Prime Minister. He says, you give me a note, not signed one. What is the issue as such? I would take up this matter with the chief ministers of my own. And he did that. And thereafter, the whole thing could be resolved.
That's very interesting.
But see, the question is, when I say that people should realize that they are human beings, and judges themselves should realize that they are human beings. This element is very, very important. If he has made it open, the Prime Minister has visited, I see nothing wrong because the whole system has changed now. Everything is open. You can't hide anything for that matter. Similarly, when he's talked about Ayodhya for that matter, that he prayed to the deity in that context. See, I do not see anything wrong in that. Why? You are in a dilemma. For instance, I'm sick. The doctors are treating me. Whatever treatment is to be given, being given. I pray to God. Similarly, judges are human beings, he prays. And they find a solution within the constitutional framework.
So that framework is sacrosanct.
Absolutely. The framework is sacrosanct. That's only to give you the balance of mind, the strength which you need to do. Solutions are found within the constitutional framework. That is the beauty of that, for that matter, as such.
Absolutely.
And therefore, see, it is more at the retirement that the criticism comes. I personally feel that he has come out as a human being, open, not hiding anything at all. I would say, I go to this extent, he has touched the Olympian heights in the contribution that he's made, but he has missed by a narrow margin the gold medal.
Okay, that's very interesting. And so, would you, just one last question, what do you make of the bail jurisprudence? Because our investigative agencies sometimes don't really follow the Article 21. And there are botched up investigations, and so the ball is totally in the court of the judge.
Absolutely. See, the Article 21 is the foundation of that. Now, our investigating agencies, maybe the ED, maybe the CBI, these agencies as such. Now, question is, Article 21 is bound to remain for all times to come. Can the investigative agencies silence Article 21 of their own by not following the procedure which is required to be followed? The Supreme Court umpteen times has said, bail is the rule, jail is the exception. And Article 21 cannot be silenced. And therefore, see, this aspect has to be realized by our investigative agencies, that they also have to function within their own framework for that matter. That's the beauty of it, that protection of Article 21 should not be denied, particularly in the political context for that matter.
Okay.
And therefore, bail jurisprudence is developing. But there are situations, there are cases where what ought to be done had not been done. And therefore, actually, factually, Article 21 is the soul of constitutional morality for that matter. I would term it like this. And it needs to be.
So, complete justice is constitutional morality.
I would say that, yes. You know, constitutional morality has not been defined anywhere. In the Constitution, morality expression has been used, but constitutional morality not. Public morality or morality as such, your morals for that matter, are different. Constitutional morality is something different altogether. Constitutional morality is the soul of the Constitution. Like basic structure, it is emerging through the different processes. Human dignity for that matter. Sabri-Wala case. The dignity of women for that matter. That was held to be the constitutional morality. Now coming to complete justice. Rule of law, justice according to rule of law is not always the best kind of justice. Why do I say this? Laws are framed. They are not necessarily covering all different situations which may arise in future.
Absolutely.
In that
Absolutely.
context.
Yeah.
Now, in that background, we have to see that constitutional morality, how it really helps in that particular process and plays a significant role. Rule of law and rule of justice. And therefore, where rule of law fails to do justice, the rule of justice, complete justice, would come into operation.
Absolutely. Absolutely.
Doing complete justice is the vision of the Constitution. Article 142 requires that. And therefore, even where the law is not in a position to help to do complete justice. Either you interpret that law in such a way that you are able to do complete justice, or complete justice combined with constitutional morality, take it forward. Certainly, doing complete justice is constitutional morality. That's the thirst of the Indian mandate of the Constitution.
Absolutely. Thank you so much, sir. We
Thank
could
you.
carry on forever, but we are short of time. Absolutely brilliant analysis. We really enjoyed it. Thank you for watching us.